Now we are. So Kenneth, you can take it away.
All right, thanks, Josh, and thanks everybody for being here tonight. Reggie came and asked if I could just talk a little bit to the group about just sort of the basics, A to Z, of starting a real estate holding company, the different sort of legal structures you might consider, and then once you have the company up and running, just sort of pitfalls and lessons to be aware of in every stage of sort of the real estate life cycle, starting with the purchasing of a property on to once you have a property under contract, and then it gets deeded over to you, operating the property, whether you're doing that through a property manager yourself, if you're renting it out to tenants, just different things to be aware of to make sure that you stay in compliance, don't get into any trouble. So I know that Reggie said it's a pretty wide range in the group from how experienced everyone is, and some newbies and some very experienced people that have ran multifamily type properties. So I'll kind of keep everything just basic and may sound elementary, but if anybody has any question at any point, just feel free to stop me, or wants me to elaborate on anything, I'm happy to dive deeper. But generally, so when you're going to start a real estate company, the first decision you got to make is what type of company do you want? There's all sorts of legal structures and options that you can have. Probably the simplest is the sole proprietorship, which is just you, but taking ownership of the property in your own name and running it as yourself individually. There's nothing that has to be done. You just buy the property, and any sort of income you get from the property is part of your personal earnings. The downside, obviously, to doing a sole proprietorship is you have unlimited personal liability. If somebody were to, for example, you purchase a single family home, somebody walks on the property, gets attacked by a dog, and has $100,000 worth of damages. If outside of you having insurance, then you would be liable for those damages, and you're the one that has to pay. You know, you can protect yourself with insurance in different ways, but another thing you can do is form a separate legal entity like a limited liability company, as sort of a barrier between your own personal assets and the assets of the company. So the company will own the legal liability, limited liability company would own the property, but you as the owner and member of that LLC would be able to get all the distributions and profit, but you're not personally exposing your assets to liabilities that come from the company's ownership of the property. So outside of sole proprietorship, you know, you could set up as a partnership if you're going to be doing this with another individual or a business entity that's going to be handling it with you. Partnerships always have some sort of partnership agreement. Many states require that they be in writing, but not every state does. But as we get into operating agreements in a minute, I'll go into more of the pitfalls to be aware of in any sort of partnership agreement. But outside of a sole proprietorship partnership, you also have corporations. That's a separate legal entity where the owners are called shareholders, and generally it's governed by a board of directors that is elected by the shareholders, and then the board of directors separately appoint and hire management structures to run the company. That's pretty rare to see in this space that y'all are talking about, just because we're usually talking about smaller companies. Corporations have a downside of being subject to double taxation. So the corporation is taxed whenever it earns money, and then whenever it distributes its dividends to its shareholders, the shareholders are taxed on those dividends. Whereas the other entities we're talking about, like sole proprietorships and partnerships and LLCs, unless they choose to be taxed as corporations, you don't have that double taxation. It just sort of all passes through to the owners. So you only get hit one time. The LLC is probably the most popular business structure we see for these real estate holding companies. They have a lot of advantages, mostly to do with their flexibility. You can set up a LLC with different classes of memberships. So it's almost like what you normally see in a limited partnership. Where a limited partnership is, you have general partners on one side that sort of involved are responsible for managing the company and taking care of all the day-to-day operations and making all management decisions. depending on how your limited partnership would be set up, whether it was a limited liability limited partnership or just a old school limited partnership, general partners can have unlimited personal liability as well. But with an LLC, you can set it up to where you have basically all the advantages you would have of a limited partnership. And so that's generally what we see whenever we're asked to form a company. That's what the clients want, is an LLC. Another advantage of an LLC is, depending on the state that you register the LLC in, you can register it anonymously, so you don't ever have to tie your name to it. The Secretary of State or whatever jurisdiction you're in, they never actually get your name directly in that filing, and so the public doesn't know who owns the company. I mean, you have to nominate a registered agent, which is somebody in the state where you're going to be operating that is available for you to be served with legal process if anything ever comes up. But nobody ever needs to know that, you know, it's Josh Ferrari that started this company. Now, some states don't allow anonymous LLCs. You have to name a member, but what you can do is set up in a state like Alabama where it does allow anonymous ownership, and then have that anonymously owned company be the owner of the company in the jurisdiction you start, so that there's still no public knowledge of who the owner of the company is. But whenever you're setting up your LLCs, there you need to decide whether or not you're going to be member managed or manager managed. Generally, what we see is that we set these up as manager managed, meaning that there is a manager or a team of managers that are responsible for making the day-to-day decisions in the company, and it's not just subject to needing a full membership-wide meeting and full membership vote anytime there's a decision to be made. And the manager can be a member of the company, so it's not a problem to do that, but it's just seems to be a more streamlined governing structure whenever we do these as manager managed. Another wrinkle to LLCs, depending on the state you're in, some states, for example, Alabama, recognizes what's called a series LLC, and a series LLC is essentially, it's a giant holding company in one. So the series, you would start the master company, and then inside the master company, you would have separate series. So let's say you wanted to buy a house on Johnson Street, you could make that part of just its own separate series, the Johnson Street series. And then you had another house you wanted on Ross Street, you could set up a Ross Street series. And even though there's only one company, the Master Series LLC, if something goes wrong with the Johnson Street series, it can never touch the assets of the Ross Street series. So it is essentially, you pay one filing fee, but you have a master parent company in all sorts of subsidiaries underneath it. Now, what I will say, you have to be careful that you only use the series LLC in a state or jurisdiction that that recognizes the series LLC entity. For example, if you set it up in Alabama, which recognizes it, and try to just operate as a separate series in Florida, which doesn't, this is such a new fangled kind of idea that nobody knows exactly what that would look like. Florida could decide that it's not going to recognize any of the series protections and just, we're going to go after every asset that's underneath the series. But if you, presumably, if you're in a place like Alabama where it is recognized, then every series would be safe from every other series, so long as you're doing the things you need to do. And so that's, before we even get into the operating agreement, every state is different as far as what it requires of its companies, whether or not they have to have annual meetings or there's different record keeping requirements you would have to have. So it's all sort of jurisdiction specific, but generally you want to make sure you're following those rules and that you are treating the LLC, or if that's what you choose to set up as, you want to treat it as a separate company, as its own entity. So you don't want to intermingle funds with your personal assets and LLC's assets outside of when you do formal distributions, because you want to make sure you have different records, all that kind of stuff, because to the extent that you were just treating the LLC as an alter ego of yours, I mean, if you're using the LLC bank account to, you know, to fund your own personal spending habits, then they can do what's called piercing the corporate veil, where basically if anything ever goes wrong and your LLC gets sued, the LLC has no assets, but they decide to say, well, okay, the LLC doesn't have any assets, but Josh Ferrari was treating this LLC as his own personal piggy bank. He was not treating it as a separate entity. Then the courts have come up with mechanisms for then, even though it was an LLC liability, they will provide a method for plaintiffs to tag Josh Ferrari individually for anything that goes wrong, so that he would be personally liable for a judgment. So it's important to always remember that you need to treat it as a separate entity from you, have monthly, quarterly, or annual meetings and record minutes, just so that you could prove, if the push ever comes to shove, that this was that you were following all sort of the corporate procedures that you needed to make sure that liability protection can't be pierced.
Kenneth, it looks like we've got a question on that from Matthew Spot. He said, isn't that anonymity feature going away in the next 2 years with the laws being pushed by the current administration?
That may very well be. I'm not knowledgeable about that particular piece of legislation that's being proposed. I know my day-to-day practice in Alabama, it's still very much something we do every day as far as filing anonymous LLCs. I mean, if the federal government decides that we can no longer do that, then that'll presumably be a legal battle that's going to be fought at some point. But I know as of today that you can, in Alabama, form an anonymous LLC, and I've not received word that Alabama intends to change that law anytime soon. But ultimately, if the federal government were to pass something that changes that, then we just have to figure out the next workaround to address that. But getting back to what we were talking about, so whenever you go to set up your LLC, every state, like I said, is different. Some people call it a certificate of formation, others call it filing articles of organization, but it's just the document that you would basically need to file with the Secretary of State or probate court or whatever the appropriate entity is in your jurisdiction to have the state formally recognize that you are starting this separate company. Then you need to go get an EIN number. I'm sure a lot of y'all have experience with that. You can do it pretty easily through the IRS's website. You need to make sure that you're filing your initial business privilege taxes or reporting requirements, whatever your specific jurisdiction requires. And like I said, every state's different. So I'd encourage you to meet with an attorney to get more information about where you are, what is required for your, state and local governments to make sure you're in compliance there. But then the next important document you'll need is the operating agreement or partnership agreement if you're a partnership. And that just sort of outlines what the rights and responsibilities are between the different members of the company. Now, if you were a single member LLC, the operating agreement doesn't matter that much as far as, you own 100% of the voting share. You can amend the operating agreement at any time. You can make it do whatever you want or make any changes to it that you need to. But it's more important whenever you have partners, whenever you have other people, whether it's, you're talking about multifamily syndication where you're going to have a lot of limited investor types that are going to be involved in sort of the profit distributions and putting up capital to get everything done, but they're not going to be involved in day-to-day management, and the operating agreement will line all that out. But for the purposes of this talk, just thinking more of a smaller type company where maybe you have one or two partners, just some things that you need to be aware of is just the big thing in any operating agreement is to make sure that you read it and that you understand what your rights and duties are under it. And just making sure that there's no vagueness or ambiguity in terms. That's what 95% of disputes in these partnerships come down to is terms were not properly defined. And then one side thought it meant X, the other side thought it meant Y. And then eventually they have to have a court to set it out. But Another issue we see in partnership agreements that when things go south is a lot of times there's not appropriate exit strategies built in, whether or not there's a method for one partner to buy out the other if there is a disagreement that they can't get past, or just if a partner dies, what happens? And there's all sorts of ways that you can structure that. You can have it within the operating agreement itself, where the different members set forth how their memberships will be distributed if they are if they pass away or incapacitated, or you can set it up with a contingency where the company is going to buy a life insurance policy on each member, and if one passes away, then the company uses the funds of the life insurance policy to buy out that member's interest, so that you know if you're sitting there running the company with your buddy and then he passes away, you don't necessarily want to get stuck with running it with their spouse or their children. So it's just a way that everybody, if you all agree on the front end of what's going to happen, it keeps you from having those problems on the back end. Similar to that, you need to have, if you don't want to get stuck in a situation where you're tied up, you get tied with a business partner you didn't pick, and that you don't want just restrictions on transfer of units, so that if you and your partner go sideways, that he can't just sell it to anybody on the street. Either he's got to give you a first right of refusal, or it might be just there is no way for him to transfer it, period. Either it just has to be a buyout between the two parties, or the company might just, if there's no other solution, just have to wind down and terminate if nobody can reach an agreement. And typically, I mean, if that's what's on the table, the parties find a way to make it work, because usually it's going to be more profitable to work it out than to liquidate all the assets of the company. But so those are some of the most common problems that we see in operating agreements. I'm happy to field any questions at this point if anybody has any other specific concerns or questions on the just membership, operating agreements, partnership agreement side of things.
Yeah, I have a couple points that I'd like to that I'd love to get your thoughts on there, Kenneth. And I know we did have one more question. Ethan was asking, if we plan on investing in multiple states, would it make sense to have a single holding LLC with multiple series multiple series LLCs underneath of it for each state you plan on investing in? Or is there an ideal structure that you would recommend if you know you're going to be investing in multiple states?
So what I would do is, if you're going to go the series route, I would confine it to a state. So if I was going to have an Alabama series LLC, I would only do Alabama-based investments in that. And if there was another state I wanted to go to that offered the LLCs, I believe Texas offers series LLCs, then I would create a separate series LLCs for Texas, because, like I said, one, there's the concern about how other states are going to treat these series type entities if they don't recognize it. But even amongst it, I promise you that there is going to be a disparity in how, in operation, different states that recognize series LLCs treat the series. So what is good in Texas may not be the same way that Alabama treats it. So I would, if you want to go the series LLC route, I would only do one series per state. Now you could also have a master holding company that owns the separate series LLCs, so that it all funnels back to one if you wanted to. But I would not do just a one series LLC that's holding different series in different states.
Totally makes sense. It's because of those laws that you're saying certain states don't recognize them. And I've dealt with that in Florida with my closings, where someone tries to close with a series LLC from another state, and a lot of the title companies won't allow it because we don't recognize those. So you need to effectively either create a new LLC within Florida to close on that new entity, or a foreign entity has another state that's not a series LLC. So
Sure.
Cool. Josh, you able to let me share screen, because I have a couple of points that I'll bring up and kind of knock them out one by one. And if you guys have any other questions, you keep throwing them in the chat for Kenneth, and we're happy to broaden the question span to any sort of real estate structure stuff as well. So it doesn't need to necessarily be the specific topics you touched on, guys.
Could be good.
Sure. Cool. Let me open this up. just had a couple points that I thought would be good to cover. All right, we talked about where we were already, basics. All right, so with Kenneth, we talked about organizational components, which was good. Now, one of the questions we get often, I know you touched on both of these specifically, Kenneth, as far as LLC versus LP or LLLP. And if you can just talk more, if you could quickly define, if someone say, hey, what's the difference between a limited liability company and a limited liability limited partnership? Like, where is it really just the structure of who's being called what? I'm sure there's a little bit more to it, but is there a way to simply define that difference?
So it's actually a great question, and one that I've sort of always struggled with, because we have set up limited liability, limited partnerships. I guess the one thing is that in a LLLP, you do have people defined as general partners, which are responsible for the management, and in theory could have personal liability, although the extra L in the LLLP is supposed to protect them as well. Whereas an LLC doesn't have to have different sort of classes of membership, whereas I guess an LLLP always will have different classes. But with the flexibility of the ways you can set up your LLC, you can essentially structure it as an LLLP within the LLC system. And I'm sure there is some nuance out there, depending on your jurisdiction, that it may make a big difference to go one way or the other. But in my experience, setting up businesses in Alabama and in different states, I've never seen really it's a distinction without a difference in most cases practically. And so we've just defaulted to always doing LLCs lately.
Okay,
LLCs.
cool. No, that's great. I appreciate that. We talked about the documentation. I guess one of the questions that I've gotten sometimes is, you're normally starting with a boilerplate, I'm assuming, with like a PPM as an example. If you're going to create a PPM for an LLC, you have some sort of a boilerplate document you're working with. Is there any sort of like, what are the common things that people don't? What's common input that you normally need to pull out of somebody that you wish they would give you up front that would make that documentation process, like creating from the boilerplate to the final document, and make that easier for you?
Sure. Well, so believe it or not, in some of these syndications we've done, whenever the clients have come to us, they really haven't even thought of the ownership, like the waterfall structure of how profits are going to be distributed, whether or not the property is going to be held in perpetuity, or whether there's a 5-year exit strategy, or just the different considerations that need to be thought of before you could even begin drafting the legal documents, because we kind of have to know where you intend to go so that we can craft the document to get you there. But it's where I'm sitting, I'm just trying to help you legally get everything you need into the agreement so that it accomplishes the goals you're trying to do. But I can't make the decision on what makes sense for either the general partners or the limited partners for financially. How is this a good deal for both sides? That all comes from y'all. All I can do is try to put pen to paper to sort of create it once you tell me where you want to go.
That brings up a good point, right? So I think a lot of people expect the attorney to be more proactive than your role really is supposed to be, right? Like, a lot of people expect you to be almost like a financial advisor, as well as like you are a legal advisor, of course, but they expect you to do more in that regard. So I like how you brought that up, where you're like, you kind of we need to give you the recipe, and you kind of make the cake of which is the actual document, right?
Exactly. Correct.
Cool. You hit on the operating versus holding companies, which I think was a question that just kind of almost came up here from Oliver. Oliver said, having an LLC directly under a trust without a holding company between the trust and the LLC would be a risky business. Let me see what. Having an LLC directly under a trust without a holding company between the trust and the LLC would be a risky, bad idea. So I guess he's saying, is there a legal, is there liability concerns if you don't do the holding company technique? If you just have a trust that holds the actual operating entity that's running the business, is there a liability benefit from having say your personal trust that owns the holding company, and the holding company that owns the operating company itself that's actually going to run the syndication? Is there
it kind of, you get sort of in a, theoretically, I could find reasons that it would be more beneficial to do the holding company, but the company that's holding versus the company that's operating, that's helpful in just sort of creating the governing structure so that we can have the way that decisions are made with what's generally the Class B member or the sponsor of the holding company, where you can have the way that their funds are distributed and the way they make decisions separate from the general LLC agreement that's going to include all the limited partners, is usually the reason we do that. It's not so much for a liability concern, because the holding company is presumably going to be an LLC that has its own liability protections built in. We can keep adding layers and adding more theoretical liability protection, but at the end of the day, I mean, I think once you have the holding company set up, that's going to solve 99.9% of problems.
Okay, cool. Next point I had here was, interaction with the CPA, because I know there's a lot of times we talk, like I said, financial advice versus legal advice, and they obviously sometimes kind of intermingle, commingle, if you will, as far as the advice there. What have you seen as far as, how your personal engagement with CPAs? Like, do you find it useful? Do you find it not useful? Like, what are the scenarios where you found it to be the most useful when you're engaging with a CPA?
So it's we've usually only been rightly or wrongly, most of the times when the CPA and us have been involved is whenever the first year's taxes come due and there's just questions to make sure that everything is complying with the operating agreement and the way the CPA wants to file everything. But what I would say is that that's another one of those front end type questions where it's best if the syndicator is proactive in meeting with the CPA and finding out exactly what they need to do to maximize their tax advantages there. Generally, every time that we set one of these up, it's always been taxed on the back end as a partnership, just because that's gives you sort of that pass-through income that's going to be most beneficial in most cases. Outside of, there are different reasons you may not want to. If, for example, the corporate tax rate was lower than the investors' individual tax rates, you may want to consider a different way. But that's just something, again, that's more on the sponsor side as far as making sure that they've got a good plan with their CPA and have all that protection in place. And then anything that we're told to do differently, we're happy to incorporate into the legal document side of things.
Awesome. One of the other things not on the list here, but that's brought up pretty often, is blue sky filings. Did you talk to that at all? If you want to kind of explain what that is, because that's a term that some investors don't quite understand.
Sure. So whenever these syndications happen, a lot of times you're going to be under what's called a 506B or 506C type capital raise, where that basically says that the SEC laws they've created exemptions from registration for certain types of offerings. And if you comply with the different requirements of whatever exemption you're trying to fall under, for example, 506C, you can have only accredited investors, but you're allowed to do advertising. I'm sure y'all talked about that before, but for example, if you're under 506C, as long as you're checking all the boxes to make sure that you're complying with that federal exemption, then you don't have to then comply with every individual state's securities, different securities rules, because you are exempt, but you still have to do what's called a blue sky filing, notifying the different states that you're raising capital in that you exist, and making sure that that you've got your Form D, which is the document you would file with the SEC to put them on notice that the offering is even happening. You then record that with the different states where you're raising capital, so that you've met your sort of compliance requirements as far as the different states, even if you're not having to comply with every individual state's individual regulations.
Awesome. Yeah, I think that's one of those things that I think you explained that super well. A lot of people get confused, like, why is this just one more layer of bureaucracy? And like, what does it mean? And it really just comes down to effectively overcoming state requirements, because we're adhering to federal requirements. Awesome. Sweet. Guys, let's open it up to the floor. We got Kenneth for a couple more minutes. If you guys have any other questions, I'll stop sharing my screen before. We got other topics to discuss as well, but I want to be as efficient as we can with Kenneth's time.
Well, look, real quick before we get a question, I did just want to kind of comment on that CPA bullet point. What I've found just, and just over the past year or so is some of the legal advice and some of the advice that the CPA might give you, sometimes it's a bit of a tug of war. What might be the best way to structure something legally might have some unintended negative tax consequences and vice versa. And so you kind of just have to, like both Matt and Kenneth talked about, is having the conversations up front with all of your, business professionals, all your support functions, to make sure that you've weighed all that and you can kind of optimize according to your risk profile.
Awesome. Yeah, no, totally agree. It's a balance, right? It's almost an art versus the science sometimes in building this out.
Sure.
What do you guys got? Questions? While you have an actual attorney in front of you to ask any sort of legal questions you want.
Come on, guys, we're paying them by the hour here.
Okay, great. I'm glad. I have questions. Hey, Kenneth, thanks so much for your time. So I had a quick question. So, obviously we're talking about blue sky laws and things of that sort. So currently I'm a financial advisor at Merrill Lynch. So I have 766, all those good stuff. So because I start this syndication, is it recommended that that my entity, my LLC that I've already created, have the sponsorship of my 7 to continue that 7, or do I just need to go ahead and just let it go away when I decide to leave Merrill and just focus 100% on my syndication?
And just to make sure I'm understanding you correctly, are you talking about keeping your Series 7 certification active?
Yeah, can I register it under my LLC or no, because I'm actually not doing publicly traded, I'm doing private placements.
Paul, it's an interesting question. I've never actually gotten that one before. The truth is, I'm not sure if you can. I don't see, just off the top of my head, why you couldn't register it under your LLC and just continue to do it that way. But I'll be happy to get your email address from Reggie and look into that and get you an answer.
Oh, that'd be great. Yeah, perfect. Yeah, awesome. And then
that's a good question, Paul. You're too qualified, apparently.
no, not at all. The exams were really hard, so I'm like, I hate to let them just go to the side.
No, valid. Yeah, no, some of my friends have gone through those. It's not an easy process, so I totally understand your desire to kind of keep it rolling.
Yeah.
Yeah, the email response you'll get from Kenneth will be $300 later. No, I'm just kidding.
Kenneth's great.
Can we have your contact info, Kenneth?
Sure.
We'll pass.
You want to
we'll
put it in the
out to
chat
everyone in Slack
Yeah.
channel. We'll definitely get everyone's Kenneth. Kenneth, please don't barrage him. He's not there for free legal advice. Obviously, he's here and because we've done a ton of work with Kenneth, and we continue to, because he's just a fantastic attorney, and he's also super accessible. But at the same time, we try not to abuse his willingness to be flexible with his time. So, all right, cool. What else you got? Paul, cut the cord and don't look back.
I hear that. Thanks, Mike. You're absolutely right.
What else? Go ahead, Paul. You got another one? Go ahead.
Yeah. So, Kenneth. So I think somebody was asking about that, because I did ask. There was another attorney group that basically is like, oh yeah, we're going to set up your holding company in Wyoming, or Delaware, or whatever state that was, because to help protect it more. And then I talked to another attorney in Texas, and he goes, dude, that's honestly going away. I think somebody mentioned that earlier. They're like, that's going away because current administration's changing that. So I guess from that, let's just say hypothetically that is true. So then it really doesn't matter where we create our LLC then. Would you say that's about right, or?
Are you talking for the anonymity concerns?
Correct. Yeah. To protect for the piercing of the veil.
Well, so the anonymity and the piercing of the veil are kind of separate issues. That they have made at one point, if there's legislation out there that's trying to do away with being able to have anonymous SEC or anonymous LLC filings, then presumably you would have to have some sort of individual identified publicly as a owner of the LLC. I'm not sure in practice how they're even going to do that, just because everything is so custom between different businesses. So I'm not sure I'd be interested to see the proposal that they're putting out there and how it can even be accomplished practically, especially when you have decades of people starting these companies anonymously, or we're gonna have to go back and sort of identify all of those companies, or what is going to be needed to comply there. But the piercing the veil, that's going to be in pretty much every state that I know of, where if you're not doing the things you're supposed to, as far as just honoring the sort of corporate procedures and treating the LLC as a separate individual entity outside of your individual self, then basically all that is the law's mechanism to say that you were running this LLC as your alter ego, so you are now going to be personally liable for the LLC's debts. But that's going to be there even if the LLC is kept anonymous, because this anonymity is for keeping your name out of just a general public search or review of Secretary of State records. But if you get into litigation, your identity is going to be discoverable if there are these kind of allegations that you're, treating the LLC as your alter ego.
Okay, so so let's say I put like 10 grand into my LLC, I could say it was a initial funding or something of that sorts, but just keeping it separate, like, oh, it's a loan from Paul, and then making payments or something of that sorts. That's kind of protecting it the way it's supposed to be, right?
Yeah, it's more of just, if you have an LLC bank account, don't use it to pay your personal power bill at your house or whatever your day-to-day living expenses are. Like, treat it as a separate entity. I mean, and that doesn't mean if you need to pull the 10,000 out of there, you can do that, but just distribute it to yourself or loan it to yourself, however you're going to do it. And then once it's in your other account, you treat it as your money. But while it's the LLC's money, treat it as LLC's money, basically. Don't use it just to run your life out of that account, basically.
Perfect. Okay, thank you.
Mhm.
Awesome, guys. What else you got? Any other questions? Oh, we do have a couple, I think. So
Matt,
Does
you raised
every
your
new-
hand.
what's that?
I was gonna
I
say
did,
Matthew
I-
Spot raised his hand.
Thanks, Joshua. I actually, so in addition to the anonymity potentially going away under this administration, there was also a thing about what this administration's future plans are for tax laws in terms of something being owned by trusts, and there was other things even included about 1031 exchanges moving forward, because currently, and this is my understanding, currently, like, if you die, those taxes just go away, like and then the taxes are gone.
The basis
And
is reset, yeah.
Correct. And under Biden's new proposal, which is one of the things that's hanging up the passing of the budget, is he doesn't want that anymore. He wants the taxes to stay with whoever inherits them. So there was a lot of things that I was reading. And actually, I think Bigger Pockets had a couple things posted about it. And I'm friends with a bunch of like CPAs and bookkeepers and whatnot on, from just as, like, how I kind of met Josh, and people were posting about it. Like, what are your thoughts on these new potential policies?
Sure.
What you need to do to get prepared for them.
And I think what you're referring to is just sort of right now there's a step up in basis when someone dies. So if, my parents bought a house for $100,000 30 years ago, and now it's worth 500. Whenever I inherited, I would inherit it at a $500,000 tax basis. Is that kind of what you're referring to?
That the step up was part of it. The other part was like the getting, the 1031 not being, a new, Matt, I forget how you phrased it, but like being, the taxes on your 1031, if you die, and like, cause you continually defer them. And then if you die, they just go away. And now those taxes wouldn't go away under like some of the proposed changes. Those taxes would become inherited.
Sure. Yeah, and I'm not privy to everything that's out there that's been proposed right now. I know that there are lots of different things floating around, as there always is. I mean, the tax code is always sort of a living, breathing instrument that changes and it gets altered with each incoming and outgoing administration. So the only thing I can say is whenever the new laws are in place and we're seeing how they're being applied, we can try to advise you at that point. But I say I will say that I don't do any sort of tax law. I do help set up the companies and everything, but I defer to CPA on issues of taxation and to other, tax lawyers, people with LLMs.
I will say, I mean, these are pretty sweeping changes that are being proposed, which in my mind means it's very unlikely to be, like if they truly get rid of the 1031 or don't allow the 1031 basis to be reset upon someone's death. I mean, there is like probably tens or hundreds of billions of dollars of implication at that point. And
That's what they
that is
were
just,
saying.
yeah, it's that is so massive that honestly, it's such a big what if scenario. I wouldn't even, to Kenneth's point, it's almost a waste of energy to like prepare for something that hasn't really been enacted yet. So once it gets enacted, sure. I mean, or fight against it. Sure. Then do something like that if you want to get political. But to Kenneth's point, he's almost just like, I don't really care, because he probably sees so many proposed changes. It's really not worth his time to see it, to really study it until it becomes official, because that's what he's going to really go off of. And even when it's official, to his point, you got to see how it's actually being utilized, in the courts. And then that's how you kind of start to, run it from a legal perspective. So,
Sure.
yeah, that's from the tax side and from the legal side as well. So if this whole anonymity thing goes away, again, to Kenneth's point, that's a massive change where there's, I couldn't even tell you, hundreds of thousands of LLCs that are anonymous. Like that is a massive cleanup act that needs to be done. And if I had to guess, what's currently in place would most likely be grandfathered. Otherwise, it's going to be such a crazy process to try to untangle the web that's already been in place.
That would be my guess. It would be something that all companies formed after such and such date have to have a individual owner identified, something like that. But, in theory, they could make it all retroactive, but it'd be painful to enforce and to implement.
Yeah, there's some people with very big money out there who want to stay anonymous, and they are definitely influencing what's going on. But to your point, politics, I hate politics, so that's what I'll say on that.
Real quick, it's probably important to point out that the 1031 has been threatened so many times in the past 20, 30 years, let's just say. I know they talked about doing away with it, I think during the Obama administration, but it frequently comes up as a point of discussion. So this isn't the first time. Now there's other considerations right now, and you'll see that they're not afraid to make changes, but like Matt kind of alluded to, the sweeping change, I don't suspect that's going to happen. They're in there negotiating, the debt ceiling right now. And so they may give up some pieces of that. Some of it might stick, but they're always going after that kind of legislation. And if you look at like what they did to cost segs, I mean, they're phasing out the cost seg now. So
The bonus depreciation.
Cost segregations are always going to be a thing. Well, are still in place, I'll say. So you can still accelerate depreciation. It's just you can't do the bonus depreciation, accelerate it as much with it's getting phased out, at least until the next administration. Who knows, it could be reset.
We do have two more questions to try to breeze through these. Justin had a question. He says, does every new acquisition require a new LLC formation? And then some sub questions to that. Is there a specific benefit to that instead of having one LLC hold multiple different properties in a geographically close relation, or is that part of the series LLC that you were talking about earlier?
Well, so it can be separate from a series LLC. So if you just had one LLC that you started and then it bought up 10 properties, you're still protected. If you're doing everything right, you're protected from the debts and liabilities of that LLC. But the problem with putting them all together, and I say problem, is probably the most efficient way to do it, to put it all in one, saves you from having to pay multiple filing fees, multiple annual reports. But if you do that, let's say that something goes really bad at one property that's owned in this portfolio of 10, then the other 9 properties in that portfolio that are all under one LLC are assets that could potentially be recovered against. So it's sort of a putting all your eggs in one basket, and just how much risk tolerance do you have for that? And I would say in 90% of situations, it's going to be fine. But if you wanted to go the extra step, if you're in a state that doesn't have series LLCs where you can't put it all in one and separating from each other, then you could just start a new LLC for each property acquisition, and you could be sure that if you got problems at one property, they're not going to spill over and affect the other.
Does that answer that question, Justin?
Yep. Thank you so much.
Sweet. And then Ro had a question. He said, just for clarity's sake, what is the nutshell recommended structure of which LLC owns what other LLC, and where are the LPs and GPs located in that structure?
So I would say that there is no like correct answer. I would say that our default and a scenario that we feel comfortable with and that has seemed to work well for the clients is we will typically start a holding company LLC, which will actually be the title holder of the property that's being purchased. And inside of that holding company LLC, we typically have 2 classes of membership, or it can be more if there's a more complex deal where you need to address different things. But in just your garden variety deal, there's going to be Class A members, which is sort of the limited partners who are going to pay money, be passive, and they hopefully collect when everything goes well. And then the Class B member, or who will also be the manager in this setup, will be a separate management company that started. And then typically the sponsorship group owns that Class B member in some fashion. However, the spread needs to be there. But that is not the way to do it, but that is an effective way to do it that we've done on many companies.
Making my little windows again, guys. All right, we're going to take down an apartment. This is going to be what we'll call this a cookie cutter. But to Kenneth's point, every deal is slightly different, right? There's always something unique. And so this is the apartment we're going to take down. So the ownership structure itself, this will be owned by the holding company. The holding company is on the deed. We'll call this one, if we want to make a name for it, ABC LLC. So that's what's on the title. When somebody looks up this property in the county records, they're going to see ABC LLC is now the owner. And from here, we'll have 2 class shares. We'll have Class A and Class B shares. Class A, these are what we typically call the LPs. Now, technically, that's not the correct terminology, to be honest with you. In this structure, they're just called the investors. Limited partners, Kenneth, let me know if I'm wrong, but they'd be technically called limited partners under an actual LP setup, an LP setup or an LP setup.
Correct.
Where an LLC setup, these are technically just called, your investors or just Class A share owners. Now, again, this is basically just money. They're passive. They do have limited liability in these class shares. Class B shares is now going to be owned by a separate, operating company, or this is more the active company, and that's really the GP ownership is part of this active company. So this ownership company here now is broken down. This is the GP, and this is what we'll break down here in a little bit as far as the GP ownership percentage. But this is where you would own in the GP share. Now, as far as percentages, like percentage of Class B versus percentage Class A, who owns how much of the holding company, that's what we'll talk about when we get into deal structure. That's not something that's what Kenneth was saying. I don't know who owns how much. Like, you need to tell me how much you want the Class B to own, how much the Class A to own, how many shares are we going to offer? Like, those are all the things we'll talk about in structure setup. But this is this is what we call this is basically our baseline, if you will. This is the going in assumption, and then we tweak it as needed. Kenneth, anything you need to correct on me on that one?
No, I thought that was perfect. It was that's the way that most of the deals I see are set up. But like I said, it can get extremely more complicated. It usually doesn't get much more simple than that. But I've seen deals that have had Class C, D, even E members, and it's all just different levels of investors in different equity splits.
Awesome. All right, this will be the last question because we've taken an hour of Kenneth's time here. So last question we got here was regarding the setup of an LLC. Is there anything specific to the documents for a real estate company versus another setup? I think they mean, like, is there anything specific for document wise if this is an LLC for real estate versus an LLC that's not real estate?
So I've had a similar question from somebody recently, actually, in a different state. I don't remember where they were. And in their jurisdiction, it sounded like there may have been. I'd never started a company in the state they were talking about, but they specifically mentioned that they had some specific real estate filing. I can tell you in Alabama, there is no difference. An LLC and a real estate LLC have the exact same formation documents. So it's all going to be jurisdiction specific. If you let me know the state you're in, I can try to do brief research and give you an answer to that. But typically, I don't think there is going to be any difference in most jurisdictions.
Yeah, Alan is the one who asked the question. He says in Texas. So
I'm not aware of any differences in Texas. Like I said, I'll do some quick research and try to get you an answer.
cool. Awesome.
Thank you
Hey
for
guys,
that.
can we give Kenneth some love in the chat and let him know how much we appreciate him coming on? And Kenneth, we know you're
round of
busy. We
applause.
appreciate your appreciate
Yeah,
your time.
thank you so much. Greatly appreciate that.
No problem. Anytime, guys. Good to meet y'all.
All right, Kenneth, you have a great night.
You too.
Thank you, sir.
Okay.
All right, moving on, guys. I'm gonna jump into the next topic at hand. Just kind of figuring out or continuing with our structure of, real estate structure. So this is where I wanted to flow into next. Of people often ask, like, hey, how do you define who owns what and how much within a structure? And because this is a team sport, right, guys? Realize that what I'm going to show you here is an example. Because this is tweaked more ways to Sunday, guys. So what I will say is, as you're defining roles and responsibilities, this is within the general partnership. So within the actual operating LLC in the structure we were just talking about. As you're looking at how you're going to define who owns how much of that entity, I really, really highly recommend trying to be as objective as possible versus being subjective. Like, man, I know, Reggie, he's got that strong facial hair. I think he deserves a little bit more because he's got a really good personality. Like you try to avoid the favoritism as much as you can, because the more you can break it down objectively, the easier it is to really negotiate amongst GPs and to really break down a deal to make it more of a business versus more of like a friendship or something that's a little bit more soft. And so when you take it over to, the legal side, it also is easier to enforce, we'll say, from a legal perspective as well, when you're talking about breaking these down. So here's one example of breaking it down. And this is way different than, other big groups. I will tell you right now, other big groups, if you're part of like their mastermind, right away, 25% of the GP is going to go to that group owner. So if we were running those groups like that, Josh, Reggie, and I would say, hey guys, bring us your syndications. We take 25% of every GP immediately. That's the way some people operate. And hey, I'm down if you guys want to offer us 25% of GP. As long as it's a good deal, let us know. But in the meantime, we'll talk more of an objective approach. And again, this is beginner series. I'm not trying to get too in the weeds here, so I'll talk on a surface level. Typically, we're looking at sourcing that lead. So sourcing a deal is a big part of this business, right? It's vital. If you don't have a deal, nothing else really matters. However, just because you found a deal doesn't mean you all of a sudden get half of it. And so this is one of the ways we've kind of broken it down in the past, is saying, all right, 7.5%. If you bring the deal and you get it to LOI and you get an LOI signed, that deserves 7.5% equity stake in this deal. From there, if someone who's responsible for getting it from LOI to closing, which is a different role in itself, you got to be on top of timelines. You got to assemble the team. You got the insurance, the lender, the legal aspect. The inspecting team, because realize in the multifamily space, it's not just like, hey, who's your local home inspector, right? You got to actually have a whole team of inspectors to go in place, lease audits, verifying, you got phase inspections as far as phase 1, maybe a phase 2 inspection. There's a lot to happen when it comes to getting a deal to closing. And so you should earn equity stake for managing that aspect of the deal. The next stake, I'll throw in roughly as 10% as an example of risk, what we call risk capital. So that's going to be, earnest money deposits. And so that good faith deposit up front that's required, which may or may not go hard immediately or, within 30 days, 60 days, however the LOI, your letter of intent kind of defines it. That also would be due diligence fees. Again, inspections are not cheap in the multifamily space. So you're looking at medium, kind of going in argument of $20,000 as an example of getting a 50 to 100 unit kind of apartment complex fully actually inspected with a leases audit and all that fun stuff. And then there's fees on top of that. There's lender fees that they're going to want to before they even kind of jump in there. There's appraisals, there's insurance deposits, insurance fees. There's all sorts of fees that kind of go along with the whole due diligence process, which we call risk capital. Now, a lot of these fees may or may not be refunded to you at closing, and they most likely will. But the problem is not the problem. The reason you're earning equity by putting this capital up is one, it truly is risk capital. So there's a chance that this deal doesn't close and you lose that money. So for putting that money at risk, you do earn an equity stake for that. Next one is what we call key principal, a KP, or just a loan guarantor. The key principal is the person who gets equity in a deal because they have money. It's the greatest position to be in, really, in my mind. It's you earn equity for being rich, and then you become richer, and then you can continue that process. And so the key principal is, they're going to want certain requirements when it comes to lending requirements, as far as the GP ownership needs to have a certain liquidity to them as far as capital that they have access to. And that's what the key principal has. And this could be split up, you could have two people effectively acting as loan guarantors, and this percentage would be split up amongst those people acting as loan guarantors. Next one is what we call investor relations. Now realize you're technically not allowed to get equity. This has been a good question for Kenneth, but you're technically not allowed to get equity just for raising money. You have to be active as a general partner in the deal. That activity could be very minimal, but just realize you can't say, hey, I'm earning this equity because I'm just raising money. That is not allowed. And so with that being said, you're typically going to say, hey, my role is going to be to raise money, but I'm also going to be servicing the investors as well. I'm going to be keeping the investor comms up, might be responsible for the portal, or if you have an investor days where you have investors come out, cutting the ribbon for any sort of developments, like things like that are going to be your investor relations. Investor relations, you see it's a pretty high percentage because, again, that includes actually raising the money as well, which is obviously a large portion of making a deal happen, is bringing the deal to the table and the cash to the table to close. All right, and the last piece is asset management. So asset management is after closing, who's now managing the property managers, right? Who's now ensuring that this project continues to operate as smoothly as possible. Honestly, in some days where I'm like, man, 30% in this example is so small because there's so much work involved in asset management. And other days where a deal's going well, you're like, oh, I'm great, I'm getting paid, and the property manager's doing their job. So it's kind of a balance of landing. Some people, asset management, they're going to offer you 10% for asset management. Other people might offer you 50%. So again, this is just an example kind of breakdown that we've kind of used as a baseline in the past to kind of objectively define GP ownership in the deal. And technically it would be called sponsor ownership or Class B ownership is the way we kind of break those down. Reggie, anything else to add to this, or Josh?
No, I think you did a pretty good job, man. Pretty simple as far as GP specifics.
Yeah. Any questions on this one, guys, before I move on from roles and responsibilities?
So that's just say, if you're doing a 70-30 split, you're saying, okay, if it's the 30% split, this is the breakdown of the 30% or
100%. Yeah.
Right.
100%.
Yeah.
Yes, you are correct. Yes. I should have 100% there. Yes. Go
I'm
ahead,
curious
Paul.
on the. Oh, sorry, Paul. Did you have something else to say?
No, I was going to actually say the only caveat to the getting paid for raising money is this is why you might want to keep your license, Paul. If you have your license, you
Sure.
can get paid.
True. Paul could, and anyone
Yeah,
else.
Paul
who has
could, yeah. No,
Series 7
exactly.
could. But to grossly generalize and to keep everyone safe, that's why I generalized here. But you're absolutely right, Alan. There are people like Paul who are specialized and actually can do that. And Paul probably knows more specifically what his requirements are in that regard as well.
Yeah, Paul, you're special.
My mom always told me that. I never knew why.
Oliver, go ahead.
So, yeah, so I'm just curious. So for example, obviously a big part of this mastermind is for us to learn how to raise capital, right? That's a big part. But for example, a friend of mine, he's doing a syndication. He's giving 50% of the GP to a friend of his who's going to raise all the capital, and he's doing he's not raising anything. So what would be a recommendation for the first deal? Does it make sense to try to raise capital like ourselves, but then maybe if we have a friend who's well connected, say, but look, if I fall short, then I would like to bring you in for whatever is remaining. I mean, what's a safe approach, for like first
You can
deal?
totally do that. I think that's as long as you have the timeline within your LOI, within your contract agreement, that's 100% an okay way to do it. You can say, I'm going to do my best first, and I'm going to try to fill in the gap afterwards. And if not, then you bring people in. The other way, if you were like, hey, maybe I have a tighter timeline and I'm concerned I might not make the raise all the way, you can say, all right, guys, I have a $3 million raise, whatever it happens to be. You can say, my goal is $3 million. And so what we've done in the past, Josh, Reggie, and I, we'd say, all right, we open it up with another partner. We'll say, first one in is the way it goes. So it's a first come, first serve kind of mentality. So we're raising money at the same time they're raising money. And the moment the money hits the bank, we kind of keep a tally on a spreadsheet and up until we hit our raise. And then that ownership, and that this over here, this investor relations ownership, that's going to be divvied up based on the percentage of ownership. So let's say you raised 2 million and that other person raised 1 million. Then in this scenario, I would say, okay, you would take 20%, that other person would take 10% GP ownership, because they're going to manage their investors, you're going to manage your investors. And so it's kind of an ongoing agreement there.
Got it. So at the end of the day, if they're great at this, they might raise everything in a week and you get nothing. But that's the risk of this approach, right?
Yeah, again, that's not a bad risk though, right? Because at the end of the day, now you're fully funded, and sure, you've given them in this example 30%. In your example, you're saying 50%. That's totally fine. If you're still running the deal and you're getting 50% and you didn't have to raise the money, now you can just focus on everything else. And the nice thing about that is, investor relation wise, all you need to do, you personally only need to talk to one person, give them an update, and their job is to spread the love, or spread the good news, or spread the bad news, right? And sometimes that's the reason why he's earning his percentage and you're earning yours.
Cool. I like it. Thank you.
Yep.
Leo, what do you got?
Hey, sure. So piggybacking off that question, when you're raising for like a upcoming property, how do you prioritize check sizes? For example, maybe like you're saying there's a 50K minimum, but maybe like a good friend's like, hey, I want to do 25. Like how does your team prioritize that?
The biggest thing there is going to be realizing there is a limitation for the number of non-accredited investors that can invest in a 506B syndication. 35, right?
Exactly.
35.
Yeah.
And so if you're balancing it out, if I'm looking at the raise, and have we done this before? We've totally done this before. So if you're looking at the raise, and let's say you're raising $2 million, you're at 1.8 million, and we'll say 800,000 of that is accredited investors, so they don't really count towards that count. And then you got another million that you've raised of non-accredited investors, and then that's been 20 people. So you have 15 people left to fill 200,000. You can be like, okay, sure, like, hey mom, you can come in at 10,000 and enjoy the deal. Like she's not going to take a spot that's real, might screw the deal for you, if you will. And so it's really kind of taking a real-time snapshot. And we have made multiple exceptions for that in the past, because ultimately we're doing this to help raise the wealth of our friends and family. Like that's one of the reasons we like doing 506Bs, is because we're raising everyone up together. And so any chance I can to make that exception, I will try to do that. With the caveat that I say that with friends and family, like if it's obviously you should know somebody with a 506B syndication. You don't want to, if the reason they're investing a small amount of money is because they don't have much money, meaning like that money is super important to them, kind of like Josh alluded to last week. I think you said, if your house burns down tomorrow, or whatever your analogy was, like
tree falls on your house
tomorrow. Yeah, if a tree falls on your house, like, do you need this money? If that test is still passed, where it's truly, this is their investing money, they don't need this money right now for the next 3 years, if you will. Then yeah, totally. I'm happy to take a smaller investment, as long as it doesn't screw the number of investors in the deal, and they don't absolutely need that money. Cool. All right.
I see in this breakdown, I don't see a lot of, I don't see anything for the the GP's personal capital. Are you guys not coming? I mean, I understand there's risk capital there to cover due diligence and so forth, but are you guys not coming to the party with any of your own cash in these deals, or how does that play into this?
That's a great question. You remember last week how we talked about personal business setup, and I said, hey, if you're planning on personally investing into your deals, you should have a separate LLC for that to do your passive investing with. And so we are personally investing in our deals as much as we can, for sure. And we invest through a separate entity that we are now LP. So we'll act as GPs personally, or within 3Beach, however we act that way. And then we'll have our separate limited LLCs that we invest as limited partners.
Yeah. So that capital is it's not on here because this is just GP. It would be added to the LP pro rata our investment.
Okay, so it's kind of I mean, not with a negative connotation, but it's kind of double dipping. Then you're getting paid on one side, and then you're getting paid as the GP, because the GPs aren't necessarily, or is it is it common practice for the GPs to not be expected to come up with capital in the deals? Or is that, what are your investor expectations with respect to that skin in the game and all that sort of stuff?
The investor expectation, you will get the question often, are you investing in this deal? And the answer most oftentimes is yes, I have $100,000 I'm putting in this deal. I have $50,000 I'm putting in this deal. I've honestly never been asked are you earning, is that as a GP share or an LP share? And sometimes I'll say, yeah, I'm an LP in this deal as well as a GP. It's normally the way I'll say it. Like I'm putting my money in where my mouth is. I'm acting literally side by side with my investors with my money. So my money as a GP doesn't have any sort of special differences. My actual risk. Now the risk capital is different. When they ask you like, well, how are you earning 30% or 20% or 40% of this deal? How are you justifying that? You can say, well, man, we're risking $250,000 just to get this deal across the table. Like that's one of the reasons financially, but also there's a massive amount of time. And without us, this deal wouldn't even happen. So I mean, there's the big justification. It's like, sure, you can go invest in the stock market if you want, but we're creating these deals out of thin air. And so that's our justification.
Yeah, and I think part of the question you had, Ro, was just what are investors asking? Like, what's their expectation when it comes to whether or not you invest alongside? And I think it's just going to depend on your investors. I've had some, like Matt was saying, that are like, yeah, are you investing in it? And if you say no, then maybe they're not interested in that deal. But if you say yes, then maybe they're interested. But honestly, most people that I've talked to haven't even asked the question, or two, they asked it and they didn't really care what the answer was. Like, they just really like you, they really like the deal, they really want to invest. And it's not a matter of, are you investing $100,000 in this deal? It's more like, dude, I really like the deal. Like, let me in it. You will get that. And oftentimes you'll see, we'll give you some of our example investor decks, and we'll say, hey, GPs are investing $1 million in this deal. Like the Riverside, I think we had collectively amongst the GPs, we had, I think, $1 million invested personally in the deal as LPs. So if we're raising $5.5 million or whatever that raise was, $1 million of it was our personal cash that we're investing in ourselves. But yeah, we'll try to highlight that. And there are times like investors have to understand too. You can say like, dude, we've done 4 deals in the past quarter. Like that's a lot of deal flow. Like that's a lot of cash going out. You don't always have to invest in your own deals if you can. I mean, Josh can attest to that, right? Like Josh just didn't have the capital early on to really invest in deals. And so he earned purely sweat equity, if you will, as a GP. That's what, the equivalent in the residential world is a sweat equity. And that's totally fine. You're justifying the fact you're running the deal. And yeah, but it is a question you'll get asked sometimes, and we'll leave it at that. Yeah, for sure.
All right. Well, I guess I was curious if it was just common. If it's common, then that's easy to work with, right? Like if you're the only guy that's not in the deal and every other syndicator they're talking to is, or the equivalent of that effectively, is it common for more so that the GPs get paid without having quote unquote skin in the game? And so the answer is that it seems to be normal, everyday common practice.
I will say it definitely happens where GPs don't have money in the deal. That definitely happens, but more often than not, the deals that I've seen, I'll say 80 to 90% of the deals, GPs have some sort of cash in the deal personally.
Yeah, and guys, by the way, a lot of times some lenders will require the GPs to have some minimum amount, and it's usually 5 to 10%, but it can be upwards of 20%. They can require you to have that much in the deal.
Yeah. And there's creative ways to get around it if you don't actually have the liquidity, and you hear that and now you're scared and think you can't ever close a deal. But yes, that is a requirement. Other business partners that have capital is a quick solution. And you can also actually get an LP that was already going to invest with you initially and just give them a slice of GP equity. And then that money then quantifies as both LP and GP. And now you meet the requirements.
Yeah. To not get too in the weeds, if you do have limited partners that are investing a large chunk as well, that does sometimes complicate things with lenders where they will force a larger investor to be a guarantor on the loan sometimes. But again, this is more surface level. We'll talk more into the weeds as we talk about money raising and things like that later.
And I guess as the GP in the deal, since I guess you kind of have the option to put money in as the GP or as the LP, what section would you rather put your money in?
You're going to have to be in the GP to get the deal across the finish line. You or someone's got to put up the risk capital, the EMD, the due diligence to get the deal closed in the first place. And then it's just an option to do LP, but it's mandatory for at least risk capital. And then if there are GP requirements for like 5 to 10% per the lender, then it's mandatory then as well. But if you just strictly don't have it, then there's some of those other creative solutions I was talking about of how to fulfill that obligation. And then the LP investment is completely opportunistic. If you have the capital and you want to do it, do it.
Got it. Okay. Thank you.
Yeah, I mean, I think I wasn't here last week or last Friday or Thursday whenever you guys had chatted. But a good example that I lean to sometimes will be like, hey guys, here's an example of a deal we backed out of because it was bad and we ended up losing, what was it, 20, 30 grand on risk capital costs to try to get this deal done. But then we realized that, it wasn't worth our time. It wasn't worth it to bring it up to you guys because it was in the end, there was definitely not enough meat in the bones that we were confident. So you can talk to examples, even you can use us as an example. If you're talking to investors, like, well, how do you justify that? You're like, dude, my partners lost 30 grand in a deal that they were trying to make happen. But the whole point of due diligence is I'd rather lose 30 grand than be liable for 5 million. You know what I mean? I'd much rather lose the 30 grand up front. I say lose, it's that's real estate tuition at that point, right? We learned a lot.
Well, and that kind of like, I guess, highlights the difference, right? On the LP, they're passive. They give you their money and they're done. On the GP side, you work for it.
Yeah. Michael, you got a question?
Yeah. Hey, how's it going, guys? You're thinking, so if you're a bottom dweller such as myself trying to get into this business and I get a deal or what I think is a deal. Somebody tells me about something and I don't really have the people around me yet. So I want to take it to somebody who knows what they're doing. Say, you guys. So instead of like an acquisition fee, I can roll in equity, or is it both? And also, when I'm sitting here looking at this breakdown, is there any reason? Well, first, let me how do I protect myself as far as like, I bring this deal and they run off with it, or like, I see signed LOI, but I would need to talk to whoever I want to partner with about numbers and what, everything like that. Correct. So, I guess that also, is there any reason why I couldn't also do the letter of intent to closing as well?
So I'll answer the first question. One of the reasons we created the mastermind like this is because it's important to have a safe place for you to be comfortable bringing deals to. I guarantee that if you were to bring it to, me or Josh, and, as we grow the trust within this group and into this little trust tree, if you were to bring it to Josh and Josh snipes that deal from you, for lack of a better term, you better believe we would cut his legs off. Like it's not, that's like, it's just not cool, man. Like, honestly, there's an ethical, moral, we'll call it moral boundary that needs to be developed amongst a mastermind like this, because if you can't share openly, then you're like, if you have a potential deal, like the last thing I want to do is let a deal die because you're scared someone's going to steal it from you. And so you need to have a trusted partner, trusted person that you can take those deals to. And that's one of the capacities that we have. We're happy to help you underwrite those deals if you really think it's a deal. And that's before LOI, right? To your point, how do I even make an offer if I don't know like if this is an actual deal or not? So that's the first question. The next question is, can you get this portion, LOI to closing? And yeah, that's all comes down to negotiation. Again, this is again a big highlight here. This is an example, right? So you can come to the table and be like, hey guys, here's how I would like to structure this GP. What do you think about this? And it's a negotiation back and forth to get the term set up front. And that way, moving forward, there's not any questions. Like the whole point of this is not to like, this is not gospel by any means. But the whole point of this is say upfront, guys, here's the deal. Tell me, is this a good deal? Okay, cool. Assuming this is a deal and we get this under contract, this is what I'm thinking as far as structure. Talk through that. And then from there you say, okay, sweet. Like, here's what we agreed on going forward. And then boom, like now we all understand the roles and responsibilities going forward. Because the last thing you want to have is confusion when it comes to money. That's where anger comes from. Is like when people expect to get paid and they don't, when people start to get pissed.
Yeah. Okay. Thanks.
Yeah. And yeah. So can you play a role here? Yeah. You can be, hey dude, I'm going to be your timeline guy. I'm going to be on top of everything. I'm going to make calls once a week. I'm going to call these people. Like, you may not bring those people to the table as far as assembling the team, but you may want to take the role of being in charge of the timeline. So yeah, maybe you take half of the LOI to closing, equity portion, because you're willing to put in your sweat equity to earn it. And the nice thing, if you were to play that role, you would then develop your own team. You develop the relationships with these people.
That's what I was thinking. I mean, as far as just, that seems like it could be huge for learning going forward if you
Yep.
could also do that,
Yep, absolutely.
Thanks.
Cool. Anything else in this one before we move on, guys? Sweet. I know I'm running short on time, so I'll try to breeze next. These are soft topics as we're talking about big picture real estate structure, business structure here. So we talked CPA. We may bring our CPA on another call, not in this beginner series. It wasn't part of the plan, but big picture here, when you're trying to find a CPA, their specific business focus is going to be an important aspect, right? You want to find a CPA who understands the real estate space. Do they need to be a real estate specific expert? That'd be nice, but you definitely want, at least they have familiarity in the real estate space, specifically in the syndication space. So if you talk to somebody and you talk to a CPA, say, what do you normally do with, cost segregation studies for, a syndication? And they look at you like with the deer in the headlights look, and that they've never done it before, they're probably not the good CPA for you. Or if they're like, hey man, I've done a handful of these, I'm happy to look into it again, and they have experience, and even if they're not a specialist, I'd be willing to let someone play ball if that's the case. But in an ideal world, they're like, hey man, here's how I like to attack them. Make sure that X, Y, and Z are checked off, and then they're a little bit more proactive in that regard. So ideally, they lean more towards the real estate expert versus someone who has never heard of a cost segregation before. So just understanding the differences there. Realize you get what you pay for when it comes to all of these kind of vendors. CPAs are definitely one of them, where just because they're cheap, it doesn't mean they're the one you should be going to necessarily. So it kind of goes back to the business focus, but looking for your classic referrals, understanding that this is not an area that I personally ever go cheap on. My CPA's for my last year's tax bill was like, I don't know, like $9,000 for all the filings that he did for me. But I ended up saving like $300,000 in taxes. So, I'm okay paying that $9,000 if he's handling all that for me. I don't need to worry about it at all. All right, tax projections. So Reggie, I'll let you talk to this. I know you're a little bit more spun up on this part.
Yeah, so a few years ago when I started getting more serious about focusing on tax liability reduction, the CPA suggested that after we got got through tax season, that say around mid-year, maybe even around October, we get together and I share my my W-2 stubs and just kind of talk through what I'm doing, what I plan on doing, and she would help me project out my tax liability, to kind of prep for the next year. And it was actually pretty useful. She gave me some advice about something that I was currently involved with that may be course correct. So it was helpful. Now I think meeting with them and the hours they spent putting that together cost me about $2,500, but it was well worth it because I avoided something that it could have cost me $50. So I'm a big fan of this. Like what Matt said, what you get is what you pay for. It's very true. I've gone cheap. I did that at the very beginning, just trying to cut costs and preserve my cash flow. And I just wish I would have done it right from the beginning. So please, CPA is worth their weight in gold.
Yeah. The next one's going to be the cadence. And so with your CPA, you're going to want to have a regular cadence, even with again, we're talking about real estate business structure here. And so Reggie is kind of our go-to with Warren Averett, who's our CPA for most of our business filings. And so we have a regular cadence with them, not that we're talking on a monthly basis, but quarterly or biannually at least, we're touching base with the CPAs as we go throughout the year. And then as you go through the end of year, which you talked about being proactive with projections. But now once we wrap up an entire year and you've reconciled the entire year's books, that's when the real fun begins of trying to the end of year prep, K1 prep. This is a big point when you're talking about raising money, letting your investors know that K1s are almost always, as much as you try to push to get them done prior to March 15th, they're almost always delayed. And so you have to tell your investors, like, hey guys, there's a good chance you're gonna need to delay your filings. We're gonna do everything we can in our power to push our CPAs to get our K1s done on time. And this is even if you get them tidied up. So here's a normal timeline, guys, right? So we'll say January 15th, you normally reconcile the books for December. So the books get out and you have December wrapped up. And then by the end of January, hopefully you have the entire year kind of reviewed and like the books are done. So you're now beginning of February with the entire year's books are you're happy and they're reconciled. I's are dotted, T's are crossed. And from there, you pass it to the CPA, and just realize if you're working with a real estate focused CPA, which you should be, that means other syndicators, other real estate investors are also doing the same thing. And right around that same time, these CPAs are being handed some books that are super neat and tidy, and and they're also getting books that are, hey guys, oh yeah, here's another IOU and a post-it, and here's this, and CPAs are trying to they're going to get the full gamut, and they'll try to prioritize where they feel they need to prioritize, and you push them as much as you can to get the K1s done, which are the K1 is what the deliverable is that you give to your investor, saying, hey, here's all the money you lost this year on depreciation, and it's a great thing to offer that to them. But all I have to say is, end of year prep, it does get hectic. Try to push it as much as you can to get those K1s done on time, because they are almost always delayed past the March 15th deadline to get them out there. Anything else you guys want to add, Josh, Reggie, for CPA stuff? Okay, cool. I know we're running a little bit late here, but any questions on CPAs, guys? We got two more slides and we're done. Cool. I think it's really bookkeeping. That's it. So this last one, bookkeeping. So as far as, again, real estate business structure setup, we talked about it last week on a personal basis. You should totally have a bookkeeper to help with your personal books if you feel like you need to. But when it comes to the real estate structure, I would say this is a requirement. If you don't have a bookkeeper because you don't feel like you're making enough profit, that means you don't have enough meat on the bones. You should not be doing that deal. Okay, like if the deal cannot support a bookkeeper's fee, then you should not be doing that deal. And so, going in argument, plan on having a bookkeeper. If you don't, you're just asking for problems. 99% of bookkeepers are going to be doing their books through QuickBooks Online. That's most people are using. There are some alternatives out there for sure. Don't want to act like there's not, but QuickBooks Online is the go-to for most people. So that you have kind of options, right? You can have an in-house CPA or you can have an outsourced CPA. That's going to be as you grow your real estate business, you have the ability to eventually put someone on salary, if you will, on an hourly wage to be part of your systems and incorporate it in your role as your full-time bookkeeper, or you can outsource it to save yourself money. Sometimes if you outsource it, you can find a fantastic bookkeeper. Like our bookkeeper, we started outsourced and we still have her, even though we could probably hire a bookkeeper on a part-time basis to keep our books. But we just really, honestly, she's fantastic from an outsourced perspective, and she does a good job. Now, does that mean as we continue to grow and our books get more and more complicated, we're not going to eventually go in-house? We probably will, like just reading the tea leaves. But as of right now, where we are, we're very happy with our outsourced bookkeeper. All right, so that's just one thing to kind of realize. Ultimately, you should get to the point where you have in-house. Now, you could go cheaper in-house. You can get a virtual assistant who is qualified in the bookkeeping realm, but you do want your bookkeeper to have real estate background. If your bookkeeper knows medical terminology and all they've done is medical businesses, they may not be the best bookkeeper for you when it comes to the real estate space. So ideally, they're coming to you. Especially if it's outsourced, you want them to have real estate experience. All right. One of the big things you're going to be managing when it comes to bookkeepers is understanding that they need to understand the difference of OPEX and CAPEX. Bookkeepers like to just categorize and say, oh, there it is, where I put these categories and it's cleaned up. But just because you had a $3,000 a month electric bill that you're paying on your multifamily apartment complex, then all of a sudden you have a $5,000 bill on top of that, and she just puts that as OPEX for electrical bills. You're like, no. I had to replace the freaking transformer over here. That was $5,000. That is CAPEX. We need to push that money aside and pull that to be a capital expenditure. The reason you're doing that, especially before a refinance, is because you're trying to make your books look as clean and as strong as possible from the NOI perspective. And so the fewer operating expenses that you can put in your books, the stronger your net operating income is going to look on the books. And so this is one thing you're going to be doing on a regular basis with your CPA or your bookkeeper, is making sure they're categorizing things appropriately, especially CAPEX versus OPEX. So when you have bigger projects going on, you're definitely going to want to pull these things out. This is Reggie, which is what we call, Reggie's our, what's the word we call you again? You're the forensic
accountant.
He's a forensic accountant. He's like a freaking I don't know, sleuth when it comes to like pulling out these things. And it's very, very easy if you stay on top of it. The moment you get behind months and months and months, you're like, what did we spend this $25,000 on again? You like start to have to question like where you spend these big ticket items. So it's better to just have that regular cadence. Systems integration, you could get your bookkeepers involved directly in your comms. Like we could get Lindsay, who is our bookkeeper, directly involved in our like Slack channels, which would smooth it out, but it also is going to increase costs because she's paid hourly. And so just one thing to, to manage how much or how little you want them to be involved on your day-to-day operations and comms, you can get them involved in your systems. There are some CPAs that or some bookkeepers that specialize in being incorporated into your systems, and that's one way that's their value add. The reviewing process, this is just how often are you reviewing the books with your bookkeeper? The bookkeeper is going to have a process where they basically send you, hey, here's what I have, but here's my questions I have. Like 99% of they should be on point, but they normally have, a few handful of questions like, what was this charged for and how should I categorize it? Again, you're directing them for what to do, but a good bookkeeper who has real estate experience should say, oh, I know you said this should be, you're calling this, we'll say meals and entertainment or whatever for the business, but this could actually be called advertising because you bought some X, Y, and Z. And so, she might help you finagle the books and categorize things better. All right. The last thing is when it comes to bank accounts here, realize there are different strategies for how you want the money to flow. From the moment a tenant pays the rent to the property manager, how does that money flow from the property manager's account all the way through your account, all the way through disbursement? Reggie, you want to, or Josh, whoever wants to take this one, as far as you want to talk how money flows just quickly from a surface level perspective, just so people get a general understanding of bank accounts?
Yeah, Reggie's
there. I don't know about that, but it's more of like a straight line. I mean, if you think about it, it's easy. Like once you get to the end and you're looking back at the barrel of the gun. So, tenant pays their rent, they give it to the property manager. Property manager typically deposits it into an operating account, and it may be an account that they have sole control over, or it could be an account where it's actually your operating account, but they're acting as your agent. I have seen both are common. And then you can make distributions to perhaps your operating account that the property manager has no access to. And then from there, you can escrow money. You can have a reserve account for your tax escrows, for your insurance escrows, and that's at that point, you might distribute your asset management fees to a separate entity. And then LPs get paid directly from the operating account itself. Now, depending on the legal structure, there could be more things involved, but that's typically how the flow of money goes from the property manager to the operating account.
Yep, perfect. Yes, just realize that it's not just, hey, tenant pays money and you have access to that money right away. Typically, it needs to go through the wickets before you realize what's going on. All right. Any questions on bookkeeping, guys? All right, so that's it in a nutshell. That's like we're trying to hit the high level of, again, this is more the beginner series, so we're not trying to get too in the weeds, but I definitely want to clear up any questions you guys have real time of understanding the business structure from the legal perspective, from the big picture CPA's perspective, the bookkeeping, which kind of hand in hand with the financial piece there, and then like the GP breakdown from a very big picture real estate structure. Again, it's an example. This is all an art, not a science, guys. And so all this can be negotiated however you want. And that's really what it comes down to, is just understanding that at least you're given a baseline here. That's what I wanted to give you guys. So at least you're not starting from like, how the hell does this work? So like to Michael's point, where like, I have a deal, but at least now you have a baseline of understanding, of a concept that you can take and you can kind of run with it and mold it to yourself. All right. What questions you guys have overall?
Hey, Matt, this is Greg. Is this in the shared folder?
Well, I will make sure this one's in a share folder. I finished the slide deck, which is obviously super impressive, but I finished it about a half an hour ago. So I'll make sure I get it in there.
Yeah, we'll add all that into the next segment. This is basics, so this will be part 3 of business basics.
Yeah, and I'll bring up the screen one more time just to give everyone a refresher for what our plan was for the flow here. So we went over creative financing from the basic perspective, personal business basics, getting a real estate company structure overview. And then next week, our goal, as much as we can, is going to be tough. We're going to try to keep it surface level, but really hope everyone understand from a beginner level, start to finish a deal. And so again, it's going to be a shallow lesson, but I think it'd be a good lesson for any of you guys who might not understand, like, how do the puzzle pieces quite connect? Like, you understand this and you understand this, but how does it kind of connect? And so our goal is to kind of show you that next week of like, I find a potential deal, And then I am now an asset manager, or really disposing of that deal on the full back end. So hopefully showing you that process. After that, we're gonna bring in our insurance rep, so you guys can ask insurance questions. Insurance is always a hot topic, especially when it comes to freaking the Gulf Coast sucks around here. Then we're gonna get into branding and marketing from a beginner level. We'll talk capital raising, and then after that, our plan is to have kind of a more of an interactive cleanup from a beginner level, and maybe some role play where we're asking you guys questions. So I expect we're gonna have much less attendance that week, as we're gonna be calling you guys out personally, but we'll see who's brave enough to stay in the hot seat there.
I
I just had one quick question. This is Dallin.
Yeah.
Get your thoughts, because I haven't looked into it. I don't know where exactly he's at, but I have a friend who's a lawyer, but also a CPA down in Vegas, kind of where I'm from. Would that be too much for someone to take on both the legal side of things and the CPA tax side of things? Would it be smarter to split that up, or would that be beneficial having someone who's kind of doing all of it and knows both sides?
I could see both sides, I guess.
I wouldn't be opposed to it. There's a lot of firms that offer both. Like if you look at what's the book? I have the book around here somewhere. I just recently read it. It was the CPA for Robert Kiyosaki. He had his book, whatever it was, about tax strategies. He has a firm that has the legal aspect of it too. It has the CPA aspect. So it's like one firm, one-stop shop type of thing you can go to. If you're a friend or acquaintance here that if he's comfortable and confident in the real estate tax and the real estate law piece, sure, I don't see it. I think the biggest issue is if you need to fire him, you're now finding two replacements. Like that's when you have a single point of failure, that's the biggest issue, is it's a single point of failure for you. But yeah, beyond that, I wouldn't necessarily recommend against it if they're well qualified on both sides.
Yeah. Okay, cool. Thanks.
Yeah.
Sweet. All right, we're 10 minutes past, so we'll call this one quits for today, and we'll reconvene on Thursday, the 25th, to go over the next session of the advanced lessons, which we're talking market analysis, detailed specifics.
We have the broker coming this week, right?
Broker's coming next week. One broker
Next
to come this week, but they'll
Okay.
be here June 1st. We're having another one of our broker connections come and talk really in depth, like even more so than we did last Thursday, about how to actually utilize reports like CoStar, how to read them, and what it is you're looking for when you're doing deeper, detailed market analysis on a broad level, but equally a specific level when you're looking at deals more granularly. But that won't be this Thursday, it'll be the following Thursday.
Cool. Awesome. Well, thanks guys. Appreciate you guys listening today.
Thanks,
Thanks.
guys.